So we're going to talk about the types of immigration applications and crucially the difference between them. So what that means is that certain applications are discretionary while others are based on legal rights. So what's the difference between these two types of applications? Well, firstly, looking at discretionary applications, the Minister may decide to create a route for certain categories of people to come to the state. An example of this would be someone applying to study. So an application to do this is made under policy, and very simply this means that the Minister creates a number of criteria, and if you can satisfy these, you may be granted permission. But it's important to note that whether permission is granted or not is entirely at the Minister's discretion. So examples of discretionary applications include an application for student permission, an application for naturalisation, or an application for family reunification under the Minister's policy. So some types of applications will involve a consideration of both discretionary factors and legal rights. So a deportation order under Section 3 of the Immigration Act 1999 is a good example of this. So along with considering statutory discretionary factors under Section 3(6), the Minister must also consider certain legal rights. And this includes a consideration of whether returning you to a country will result in certain harm being caused to you. And if this could happen, then the Minister is legally prevented from returning you. This is called the prohibition on refoulement. And if you're at risk, then the Minister has no discretion and you can't be returned, so you must be granted permission. Other types of legal rights that must be considered include private and family life rights under the Constitution and the European Convention on Human Rights. Again, if your removal or refusal will result in a breach of the rights, then you can't be removed and you must be granted permission. Examples of applications made on the basis of legal rights include an application to accompany or join an EU citizen family member in the state, an application for international protection, or an application for family reunification under the International Protection Act 2015. And while a refusal of any type of application must always include reasons, refusal of an application made on the basis of legal rights has to contain more detailed reasons. And certain other legal obligations also have to be complied with. Also, it's important that your rights haven't been breached. So if there are any errors in the decision, then you may have a legal remedy available to you, which involves asking the courts to review the decision. So come and talk to us at Young O'Reilly Solicitors for immediate legal advice on this as well as any other immigration related issues.